Welcome. Hopefully, we have a productive evening. So, welcome those of you who are coming in. I see you there. As always, I'm going to let everyone come on in, give everyone a few minutes to get notifications and to drop in. This is where your questions go. You tell me hi, or you write in your questions. We will focus very, very specifically on co-principal. Hello, those of you I'm seeing a second time today. I will apologize in case I seemed a little frazzled and frustrated the first time I saw you. It was a very long day and we ventured off topic for more than 40 minutes by my count. So that obviously was not an ideal situation. However, I think it was also important that I gave the questions that I had the time that they deserve, because obviously the VIP community has been under a lot of pressure, a lot of stress. So while I was frazzled that it took 40 minutes to cover it, I am not going to regret the fact that I did give that importance enough to address it, because again, VIP community has been under stress. Twitter VLM has been witnessing the effects of what happened in the last couple of weeks, and not just mentioning that, but for the last couple of years. So I don't regret that. However, we will stay focused. All right, so it looks like we've got a decent number of individuals coming in. Before I start on the actual topic, I'm going to ask very quick questions to make sure that everyone can hear me all right. So that's the first question. Can you guys hear me okay? Is the volume on this good? If we are good to go, then I'm going to get started. So 1 yes, if you can hear me okay. If the communication looks all right, then we're going to get started. Yes, loud and clear. Yes, loud and clear. Excellent. Thank you for the responses. So let's move on. Earlier, we discussed the fact that South Korea functions in a civil law system, which is different from a common law system. There are approximately, and again, give or take, about 150 countries that have a civil law system, including France and Germany. Germany is really the country that has heavily influenced South Korea. Over time, because they were under Japan's control, a lot of the laws, the way it's practiced, even though it's civil law, shows a lot of Japanese influence. And what you're going to see with the co-principal is going to be that extremely weird and yucked unique mixture of the influences that South Korean legal system has from the Korean laws that existed during the Joseon time, which was also influenced by China, by Confucian, and then Germany, and then you've got, in particular, Japan, plus now in more recent years, in the last about 20, 30 years, I would say more 20 American influences. So co-principal. We're going to work on answering questions as well, but let me read the questions and then we're going to get started. We're going to cover your question about the worst possible sentence. Let's go back and define what co-principal is to get started. So let's get started with what is co-principal to begin with, and how it differs from some of the other things. And then we're going to break it down one by one. So your question will be answered naturally in the process of going through all of these stages. So The word co should be thought of as joint, so a joint principal. A principal in a criminal law is basically the main offender. The main offender is the person who actually commits a crime. So a co-principal is then someone who is also a co-defendant for that particular instance of crime. We don't always call it a co-defendant because they might not be tried in the same trial together. In terms of SR is not in the same joint trial with another individual. They're being held separately. However, even the trials are being held separately. They are being charged for the exact same instance of a criminal incident. One person who's not in SR's trial is the principal, the main principal. SR is the co-principal. There are two ways that a principal can be defined further. And the easiest way to think of it is there's a primary and there's a secondary. Now, South Korea doesn't use the words primary and secondary in their codified system. However, that idea still exists. It's an undefined idea that has been heavily influenced from the US system, where we have first and second degree principles. A first degree principle is literally equals to the main principle, period. A second degree principle, on the other hand, is who might actually have not committed the crime. So when you think of a co-principal, you might be thinking both people breaking in, entering. One person is breaking a window, another person is breaking another window, or one person is holding a gun and another person is holding a gun in another place. You think, this is co-principal. It doesn't have to be that way. If it was that way, then both of them would be principals in the first degree. Principals in the second degree would be something slightly different, where the main principal is sticking up a gun when robbing people, or sticking up, the local bank, while the second degree principal is not directly involved with the crime. So some of the elements of acting as a principal in the second degree are a presence at the scene of the crime. So they're there where the crime is taking place. A consent to a felonious purpose, to an illegal purpose. Number 3, I would say a contribution to its execution. Now, in terms of SR's previous 9th indictment, which was instigation only, there was no direct evidence whatsoever that he actually did anything. However, in order to charge with co-principal, there is this idea that, again, exists, that you can be a silent co-principal. A silent co-principal may not only not do anything during the commission of the crime, but might actually not do anything immediately after the commission of a crime. What do I mean by that? So Tom is the principal who's robbing the bank. Sam is the getaway car driver. And Jane, I'm using a girl, Jane is standing at the corner of a street doing absolutely nothing. Tom finishes robbing the bank. Sam drives the car and goes away. Eventually, Jane leaves as well. Jane, in this case, is a co-principal. Jane is a co-principal in the second degree. Tom is the principal in the first degree. Sam is a type of accomplice, given the fact that they drove the vehicle away. they would most likely be considered an accessory after the fact. So there are many different levels of participation in crimes that people look at. So parties to, I guess, how would I say it? Parties to the commission of a crime. There's several different ways to look at it. So I mentioned accessory after the fact. There's also possibility of accessory before the fact. Let's say that there is also a Susan. A Susan provided the tools for the robbery that took place, but didn't do anything else. That would be accessory before the fact. So as you see, there are two types of principles, first degree and second degree. And the second degree principle is still a co-principle, even if they have not done anything. In this case, as they had no evidence for instigation, they quite cleverly and at the same time quite disturbingly upped his indictment charges to a co-principal. I keep on mentioning the fact that it's clever. I also keep mentioning the fact that it's disturbing for two reasons, really. It's clever because if they did not do it, then the prosecution was looking at two possible things that would happen. One, their case for instigation was so incredibly weak, there was zero evidence for anything, that they would have to either withdraw the charge, which they wouldn't do. I never expected they would withdraw the charge, or they would have to just quietly sit and wait for the verdict. And the verdict on the instigation would have come back not guilty. There was very, very little doubt in the case that the judge would have found instigation as not guilty. It's not only something that I realized, it's something that the prosecution realized, that instigation has zero evidence to support it at all, and there needs to be certain amount of footprints to show that SR instigated, he incited the commission of a criminal activity. And with that lacking, there is nothing to support those charges, not even breadcrumbs there. So knowing that they would lose that particular indictment, they went about and did something that, again, as I keep on saying, is clever and concerning and disturbing. It's clever because they took a losing thing and they turned it around into something that now the defense has to address. The defense has to address this from scratch because the hearing already ended and because they did not want to take extra time in a court. The defense has chosen to address this in written format. That has some pros, but as many people have pointed out in other lives, that paper presentations also have some cons. So doing a tactic this last minute throws the defense in a particularly, what would I say, surprising spot, because they weren't prepared that this would happen. Just as I did not think this would happen. I thought that it would be number two, where they would just leave it alone and it would come back not guilty. I knew that they were never going to go with option one, which is withdrawing the charges, because, hey, they really need a conviction. But I did not think that they would actually be able to go back and find a loophole. And these are loopholes because legally it's possible to do this. And use the law. Again, they're using the law. They're not breaking it. They're using the law to change the type of indictment. So at this point, the defense is at a slight disadvantage, at least for this particular one, because they weren't previously prepared for it. Through 24 hearings, They've prepared for all of these other different indictments, including when they added the ninth one. It was still added further on that they had time to build for the ninth. This one, when changed, even though it's still the ninth indictment, was done so last minute that time became a factor that is now not in favor of the defense. So as I am been talking since the first time I said, for me, I'm very less worried about Twitter concerns. If there's the judge has already made up his mind or not. As I said, I've already explained that during the Instagram live, but I'm more worried about the legal parts of this particular indictment. So with less time, his defense is going to have to try to completely break apart, or at least poke a large enough hole in that particular indictment that they create reasonable doubt. So the prosecution's job is to present their side, their theory of a crime, as it were, which they're allowed to do. In case of a co-principal, if they're claiming a co-principal is someone who has not actively participated, they're literally claiming that the co-principal is a co-principal in a second degree. In that case, for second degrees, they're allowed to bring an indictment based on a legal criminal theory or a legal theory of crime. And they did. So now their job has been done. They've presented it. The defense has to break that down and turn that in. How hard would that job be? How hard would that job be? I think that's where I'm going to answer that, and then I'm going to start answering some of these questions here. Also keep in mind, it is like 11:24 p.m., almost midnight, so I will attempt to keep this at a decent time limit for myself because I still have work tomorrow morning. How hard will it be for the defense to break apart the new case? In order to break apart the new case, there's a couple of things that has to be done. They are going to have to argue about complicity. South Korean law is based on codified system. However, as I've also mentioned, throughout time, it has evolved to incorporate some of US laws as well. So the codified system is very, very German with some Japanese influences. The morality of it is highly influenced by Confucian law, while some of the modern adjustments, allowing of precedent, that's American influence. So while it is very codified, when the judge makes a decision, the defense lawyer can still present older cases to show certain precedent. Now, unlike America, where precedent itself is a type of source that we use for law, not just codified law, but precedent itself is our law. Over there, it's not everything, but it can be added as supplemental material. I bring this up because it gives the defense the opportunity to be able to find older cases and to use those at the same time as using the codified law, at the same time as using SR's testimony and witness testimonies. Remember, there is a written witness testimony that was presented by the prosecution. So it's going to be a combination of several things. It's going to be a combination of the codified South Korean law. It's going to be SR's testimony given. both live and anything else they need to add in later on in the written format. Their response, their direct response to the prosecution that the prosecution has entered, as well as their rebuttal, as their counterpoint to the witness testimonies that were submitted for this particular indictment in a written form, as a written testimony from the primary offender. So after putting all of that together, they're also going to then search for precedent. Are there precedents involved in this case? I have practiced in South Korea. It's not my primary place of practice. I live in America, but I practice in several different jurisdictions. I've had the experience of practicing there, and while doing so, I've come into contact with enough court systems, enough cases, that I have seen certain variations of where secondary degree co-principals have been brought to trial and how those have been treated. Not every time a co-principal is brought do they end up being found guilty. A lot of times they do get acquitted, so acquittal is definitely possible. But I won't go into details of that story unless someone really wants to hear some of the particular ones. I will instead read out loud the questions and start answering a few one at a time. I will pause wherever I think that they're fitting into the text that I'm giving you or the lecture that I'm giving you, and I will try doing it that way. So, okay, here goes. Here goes. What is the worst possible sentence this indictment can bring? Just so we are prepared for the worst. What arguments would need to be made to get it down to a suspended sentence if possible? So I'm going to scroll and see if there are any other questions that are exactly alike or very much alike. And then we're going to try to break that one down and answer that. So basically, it's someone who basically didn't call the cops when they should have, and it's merely a bystander. Very much similar to being a bystander, except in this case, they assume that this bystander approves of the crime taking place because they're standing by. Maybe they know that person. Um, I'm actually going to go ahead and give that example of one of the cases that I was talking about, but I didn't before. Because you brought up the bystander, and that flows straight into it. Okay, so this actually took place. There's this case where I need to find names. Okay, we're going to make up a couple of names, okay? And just because we don't want to mention real names. So there was a case in which there was someone who was going to steal cars out of theft. There was a group of people who wanted to do this. The group consisted of the primary main. It consisted of the person who advised the primary person. So aiding and better. So they were aiding and abetting them. Funding person. This person actually funded them, but didn't do anything else. And while during the commission of this crime, two people were in there. They did not expect that things would go wrong, and it went very, very wrong. I shouldn't laugh, but when you commit crimes and you take weapons with you, sometimes things can go wrong. The co-principal in this case was someone who didn't even plan to be there, did not know the crime was going to happen either. So what was happening during the commission of the crime is this. The main person who's about to commit the crime has a weapon. Their accomplices don't, but they get caught, unexpectedly caught, and their options are limited. They could run away and hope that they don't get called on, police don't show up, that their face is not recognized. Yes, they had their faces showing. Or they could beat that person up. So that poor person was beat up. At this point, the accomplice actually agreed with beating them up, hoping that that would help. What was even worse was the main guy, he cracked, again, pressure, and who knows if there was other things involved, but he ended up killing the individual who caught them. So now things went wrong. Forget about stealing a car. They got caught. They beat up the person who caught them. And then the main principal killed the person. The two guys run out. They run out. And as they're running out, right around that same time, who would have thought one of their acquaintances who knows them just happened to be outside, like literally outside of where they are during the commission of the crime, right outside that door. Right outside that door. And that person unwillingly, unknowingly, then became charged as a co-principal bystander. One of the main differences is with the bystander, you have no personal relationships, no prior knowledge of not only the crime, but of the people involved in it. In this case, this poor person, this poor person who was charged in that crime gone severely wrong, was acquainted with that group. In that particular case, the prosecutors made the argument that it is not a coincidence. It is not a coincidence that they were there at the time the commission was taking place, right outside. They argued that this co-principal was a lookout. They argued that this co-principal was a lookout. It was not a coincidence. And they indicted him. This particular case went through two levels of court. It went through the court of first instance, which is where SR's case is right now in general court. And he got found guilty the first time around. They couldn't shake that particular claim at that point. It was a fairly big case, as I said. Someone was murdered. It was appealed. Both the prosecutor and a defense have the right to appeal if they feel that a court's decision is incorrect. Now, whenever we talk about a court's decision, we don't assume naturally, if we don't like it, that it's because they're biased and they're unfair. What we instead look at is, what are their legal reasoning for it? After reading the legal reasoning, if we don't agree with it, then we tell them, your legal reasoning is incorrect. Why is your legal reasoning incorrect? These are the reasons why. And we write that up and we submit it in the form of an appeal application to a higher court. The higher court then reads all the reasons why the defense or the prosecutor believes the court's decision is incorrect. Not that it's unfair, or we believe the court's completely biased and already made up their mind, but they're incorrect. They didn't apply a law the way they should. They didn't interpret the law the way they should. They didn't take certain factors into consideration, and those factors are essential to proving the elements of a crime. All of these things. They were able to convince the higher court, known as the High Court, the court of second instance, that the court of first instance made a decision, and that decision was lacking because they didn't take certain things into factor. They then went through another process of legal system. At the end of their high court hearing, the high court judgment reversed the one in the lower courts, saying that the co-principal was innocent. The co-principal was not really a party to that crime. They were unfortunately associated with the criminals. They were unfortunately at the wrong place at the wrong time. They were able to do that. And I bring that up for two reasons. One, to talk more about the fact that you mentioned about a bystander, it could be very similar to it. And two, as I mentioned, that because South Korean law has evolved a little bit and now allows certain US inputs, using examples from their own legal system of prior cases can further help the defense build their side. So there are precedents involved where co-principals are eventually, if not immediately, but eventually acquitted. And I'm specifically bringing this one up because just in case you think that a guilty verdict at this level is the end, it's not. It doesn't end here if there are guilty verdicts, whether it's on this particular one or it's on the other 8 where he has pled innocent. Those do not mean it's done. Those mean that we've got a battle that's still ahead of us. That's what it means. So I brought that particular case up to illustrate these particular points. Yes, that particular story took place in South Korea. South Korea, which is again why it has the power of illustrating how co-principal can be so easily charged and sometimes even found guilty. But at the same time, because there are checks and balances in the legal system and the ability to appeal and show why a decision is incorrect, there is also that opportunity to fix a wrong decision. So I want to make sure that everyone goes back and remembers, even if there is a decision that is incorrect due to legal reasoning, there is opportunities. There is the high court, and if at the high court it doesn't happen, there is the Supreme Court, the highest court of the land. So I'm going to read questions again. If it's directly related to this line of thinking, I'm going to answer them. Otherwise, I'm going to go to the next question. So let's see here. Okay, so this one I'm going to answer because it's kind of sort of related. Did the witness not come into the court and say they didn't want SR to get punished? Yes, that happened. There were 2 particular witnesses to this criminal instance that the indictments arise out of. One of whom did not believe this was a crime that took place, and even if it did not believe SR has any liability, did not want him punished. The other individual was highly shaken by the incident. However, that individual had no personal knowledge of SR's involvement. The only way he knew of the word SR or the name SR is because the investigators had pointed out, oh, this was SR's doing. So yes, it's linked to the question at hand because now that the charges have changed from instigator to co-principal, this tiny bit of information can still be used by the defense. It can be used, especially the person who didn't want punishment, to show that perhaps it was not a crime itself. Now, I don't have all of the detailed facts in this, but that's a potential defense, that a crime didn't happen. If a crime didn't happen, there cannot be a principal and there cannot be a co-principal. So that's one potential way that they can go, since one person clearly did not think there was a crime and it didn't deserve punishment. It was just regular misunderstanding at an evening out, and that's how that person saw it. However, there was that other individual who was quite chicken up by it. So keep in mind, it won't be an easy defense to even try to say a crime didn't happen, but that is one venue. So I'm throwing that in here. Okay, so here's another one. Didn't the party involved say he was not present, that he was not out there in the alley? That is, as we read, that he was not out in the alley. However, he was, I'm assuming, present at the scene, which is more than the alley. He might have been in the location. So whenever we're talking crime scenes, we don't necessarily mean the exact spot. In my previous example, the crime was taking place indoors while the poor dude who just happened to be there was outside, like literally outside his door. So your example of the alley versus him not being in the alley but in the building is very similar to that again. I'm going to read the one below because, again, very related. So he's considered as a alleged, very good, co-principal because he was there, was waiting for a moment to leave the bar, and then left without reporting to the police about the whole incident. That's exactly it. Because this took place, because he happened to be at the scene of the crime, because he waited enough and he left, and there was no reports to the police, they, in their presentation of a criminal theory of a crime taking place, are assuming, are theorizing, because that's the word they use for these particular types of cases. They're theorizing that he was accepting, willing, in agreement that whatever was about to take place there, take place. In SR's case, there's one other reason that the prosecution can say this. That doesn't mean it's right, but it means that they have one other reasoning they can throw in. And again, remember, we're talking about a different legal system, one that's based on civil law, but has elements of Japanese system, which is also civil, but they practice theirs quite differently, and Confucianism in there, and then, of course, the more modern mixture of American. So keep all of that in mind. We're talking about a highly evolved system that is different. It's different from the ones in your own countries. Okay, keeping that in mind, the other argument that the prosecution has, and I don't know if they made it because I haven't read their full document, but they do have this particular argument if they wanted to, is for them to theorize that SR was in agreement, in silent agreement. They look at how SR might benefit from this. Does SR have a benefit to the main offender committing a particular offense? And in their mind, the answer to that was yes. I'm going to take a sip of water and let you digest that for a tiny moment. So in their mind, the answer to that was yes. SR does benefit from the action, and what was that benefit that the prosecution sees in their theory taking place? In their theory, they see the benefit that an argument took place before. That argument was heated. Um, and SR obviously was upset by this. And SR reached out to someone, letting them know what happened. So if that person then brings other people along and quote unquote deals with the person, you cause the fuss, then that is taking care of SR's problem. They are taking care of someone who upset SR. They're viewing it in a very gangstery fashion or a very high schoolish fashion. Like my friends have been, harassing someone, and that someone called their friend, and their friend showed up and said, "What happened? Hold on a second. Let me call a couple of more people." And then that person's like, "Okay, go ahead and call them," because he's hoping those couple of people are going to come and then in turn mess with the other party. And that's the way they are viewing the benefit, in a very gangster slash high school fashion, because you see this in gangster movies or you see this in high school where kids do these kind of things. um, so a lot of that theory that I mentioned, theory of crime, is based on these type of strange reasoning. And again, just because the reasoning is strange doesn't mean that it is illegal reasoning. It still falls within the perimeter of the letter of the law. And I think that's what's going to be frustrating for many, is that there are certain things in the law that aren't clearly good or clearly bad, but are allowed. Um, as I said before, just like the interrogation tactics, you're allowed to use deceit, not coercion, but you're allowed to use deceit. And that's a gray line. That's a morally gray line. Similarly, there's other morally gray lines within the law that fall into the letter of the law that are allowed, but will leave the average person going, wait. So let's see what else there is. Yes, the whole incident started from the moment he got into the little quarrel with the drunk person. And that's really why I said it's kind of like a gangster mentality or a high school mentality, why they think that SR would have benefited. And if he would have benefited, then he was silently in agreement with whatever these people did when they came over. Because I'm so mad that this happened. I would love to get even without having to do it. Okay, so let's move on. Well, that depends. If that was SR's only interaction with the person, then it would be up to the pros to prove he was aware of the confrontation afterwards. You're correct in the fact that so far there are all these theories. And because there isn't a separate hearing for this has been written out in a paper format by the prosecutors. If the prosecutors have not done a full, thorough job of presenting this theory and using support to back it up, legal support to back it up, then they haven't fully made their case yet. And it is up to them to make the case. So that's very good. I see wow followed by the word Nam, because yes, this, as I said, is possibly, in my personal view, the most bizarre thing that I have seen in this entire case take place. The most bizarre. And I called this entire thing a circus when it first began. So when I say this is the most bizarre, I literally mean this is like the most bizarre thing I have seen. I'm going to read the one at the bottom. So it does not matter if the principal denied the involvement of the other in the crime. So this is a really important question. It tells us a couple of different things. One, it asks us to consider if the principal says that I did this by myself, I solely committed the crime, this person did not, does that let the co-principal in the second degree off the hook? And the reason why I mentioned earlier that this was the one thing that took me by surprise and had me a little frazzled and worried was because you're right. In this particular instance, even if the principal says, I committed the crime, they did absolutely nothing, it doesn't matter unless they can themselves in their statement show that person did not know what I was intending to do, and that person did not support my actions. So for the principal to be able to give a statement that helps the co-principal, the statement has to be much more than they did not help me, I did this by myself, or they did not call them, I did that also by myself. It needs to be a whole lot more than that. The co-principal would have to have someone, in this case the principal, state very, very clearly that that person did not know who I was calling and for what purpose, had no idea of what those individuals were about to do, was in no, absolutely no frame of mind to want revenge, make the other people pay, make them feel humiliated, punish them. He had no such thinking. He was not in that mental state. And he most definitely did not support my actions. So for it to matter, the principal would have to do more than just deny. The principal would have to have said all of those things. The principal in this case, unfortunately, was not present in that courtroom. They submitted paper docs. Another reason why before it didn't matter was because it was instigation. Those paper docs could not have gotten SR convicted on instigation because there was none. At that time, those paper documents were not something that created a disadvantage for the defense. At that time, it was perfect. They had a great defense and it would have resulted in a not guilty. But now with the new charges, the fact that there isn't a direct cross-examination creates not a very big, but a slight advantage for the prosecution. And if we're talking about advantages, the prosecution has been attempting to create these advantages step by step by step since the moment they started charge stacking. They know that legally they can do this. They know that while it might be morally questionable and in a gray area, it falls right into that legal thing, and that it creates advantage for them and a disadvantage for the defense. They've been charge stacking. They've been changing up what the prosecution originally said to what they say later in the case, such as revising indictments, adding new indictments in the middle of a trial. They've been doing all of these to create that advantage. So right now, for this one indictment, the prosecution has created a slight upper hand. Not a very big upper hand yet, but slight, because of that, because the paperwork does not allow a cross-examination. The reason it's slight and not very big is because the defense has said that they will address this in their own written document. addressing it in an own written document is going to be tedious. They're going to go sentence by sentence, line by line, word by word. When I go over documents, I use a ruler. I don't have it in my bedroom, but I have a ruler. I hold it up against the document. I put the ruler, I read a sentence. I move it down, I read the next sentence. I make notes on the margins, on the sides. I have highlighters. I have different colored inked pens. If I have a question, I put a question mark. Depending on how immediate I need the answer, I immediately go to my library database to search it up. LexisNexis is my friend. Those of you who know how amazing that particular law source is. If it's a legal case from Japan, then I obviously have to turn to my Japanese resources or to my South Korean resources. I've also practiced in Egypt, so sometimes my Egyptian resources. But the point being, doing that is meticulous, line by line, catch every word, every sentence, every phrase, figure out what they're saying and where is there a gap in their legal reasoning. And again, it has to be legal reasoning. It cannot be normal reasoning. It has to be a legal reasoning that has a gap. Perhaps a fact is missing. Perhaps elements of a crime are missing. And once you've gone through that, mark that thing up, you start writing your own little file that's probably just as thick, sometimes thicker than the one that the prosecution turns in. So the defense still has that ability to do that. It's going to be tedious, and they don't have the advantage of being able to now quote the main principal after having cross-examined them and having them answer certain things, the ones that are going to be necessary for this particular defense, for this particular indictment of co-principal. So that, as I said, creates a little bit of an imbalance, and that's what I've been nervous about. Prosecution really pulled a wild card by updating the charges. Yes, they did. They really, I mean, yes, they did. There's no other way that I can get around saying that other than yes, they did. I did not see that coming. I've gamed this out various ways. I gamed this out various ways, including several worst case scenarios as well. But they did not include this. So I'm not too proud to say that I did not game this particular move. But wild card, as you say, I did not game this move, but it was there. And what happens next is going to really depend on the defense, how well they go through all of that. And those who asked what they're going to use to build, again, let me remind you, they're going to use the legal code in South Korea. They're going to have to use legal reasoning. They're going to have to use SR's testimony that was given in court and have him answer anything that was in the prosecutor's statements, but weren't asked in court. Because remember, the prosecution statement's a lot bigger than what was simply asked in court. So he's going to have to answer those. They're going to use the primaries, the primary main offenders in first degree, meaning other dude whose name I'm not mentioning, his testimonies. And then they're going to hopefully do a very good job of digging for precedents. While precedents don't have as big of a part in their system, because again, it's civil law and not common law, it still will help pad the defense's side, and every little bit helps. So hopefully they're going to go through and look at several instances where co-principals were found innocent, where co-principals really happened to be at the wrong place at the wrong time under the wrong circumstances, where they weren't a party to a crime, but unfortunately they were bystanders caught up in it. And they're going to have to find those particular cases. Researching certain cases in South Korea is definitely hard, especially if you live abroad, but his law firm is right there in Seoul. There's an entire legal team. I am going to hope, and I'm going to pray that these team are or by now, because it's been a long time already, it's the 15th, have been working full steam and have pulled all-nighters if necessary to pull up the necessary cases to help back up why they should use a certain reasoning. So that's what the precedent is for. This is why you should use this reasoning. It's there. These are some of the other previous cases, and this is why you should think this way. Yes, the military prosecutors basically use his statements during the defendant questioning about the charge to upgrade. Yes, correct. The prosecution will probably get a conviction then on co-principal charge. It depends on the defendant's arguments, yes, but based on everything we know, a conviction is likely, in my opinion. Possible to get reasonably taken down. So if the principal plead guilty, then immediately the co-principal becomes guilty too. Great questions. So we're going to answer all of these one after the other. And because I'm going to take my water because, as you know, I have severe dry throat issues. All right, so here goes. First, I'm going to answer the second comment first. It depends on the defendant's arguments. Absolutely. Right now, that particular one has such a great pressure on the defense. But yes, it really depends on how good a job the defense does to break it up. Because as the person above you says, based on everything we've heard, it looks like there is a higher likelihood for this particular indictment to result in a conviction than not. So yes, again, to both of those, both of you are correct in the sense that simply if we only look at the prosecution, there is a higher likelihood in this particular indictment to get a conviction than on, say, some of the other indictments. However, the person below you is also correct that that is still not 100% given because a lot rests on the defense. Can they poke a hole through this? If they can, if they poke that hole through, if they have, then we're back on even grounds. I say even because then it's going to be a toss-up. Then it's going to be up to the judge to take all the factors into consideration and think, is this doubt that I see reasonable? And it is a discretionary judgment is discretionary. So we might end up disagreeing with the judge, or we might end up agreeing with the judge. But his judgment will be discretionary. My hope is that he doesn't have to make that judgment until the defense has created a more level playing ground for this particular indictment. For the other indictments, the defense has a very good ground. This is the one that had driven me a little nuts. Right after your line of statements, there is another one which is more of a question, but again, so incredibly relevant and important. So we're going to sit there and address this. So if the principal pleads guilty, then immediately the co-principal becomes guilty too. Um, First thing we want to know is that because it's a codified legal system, they don't have it written down that way, Pam. So when I say codified, I mean there isn't a book that says when A confesses, B automatically is guilty. So there isn't a book with that written in it. However, because there are influences from the Japanese system, and the Japanese system and the Korean older system is heavily influenced with Confucian uh, ideals. Um, they do intend to go that route. If the principal is thought to be guilty, then in most cases, it's highly probable that the co-principal will also be considered to be liable in this particular case. I think I'm having internet issues. Let's see if it stabilizes. While I'm waiting for it to stabilize, I'll just drink some more water. The reason I use words like highly likely, highly probable instead of 100% saying something is because when you practice law, especially if you practice law in different jurisdictions, and would guarantee anything. You cannot guarantee any outcome. If you do, then you're going to find yourself in really bad situation in your legal practice in your life, especially if you're a human rights lawyer. You don't guarantee numbers. So highly likely as opposed to highly unlikely or moderately, or so I'm going to say to answer if the principal pleads guilty, it is highly likely that the co-principal would be theorized to have possessed that same guilt. Why again? The defense is so important. The defense is going to be very, very important now more than ever. Okay, the one below. That person said he assumed she was involved in who they called okay, so I'm assuming that we mean that person as in the witness. I'm not going to answer that mainly because I'm not absolutely certain I understand the question. So I don't want to give an incorrect answer. If I don't understand the question, I might be assuming incorrectly and saying something. So I see you have another statement below, so I'm going to try to go to that instead. But before that, there's one above, or rather one below. Felt like they're gonna write he's guilty on crazy. As I said, sometimes even when things fall within the letter of the law, it is a circus. Let's just go back to calling this a circus. The most bizarre thing I have seen. The most bizarre thing I have seen. I'm just going to keep saying that in order to emphasize that I've practiced law in a couple of different countries. And the most bizarre thing I've seen is happening right here, right here. Falls all within the law. But bizarre, bizarre, and morally questionable. Legal, but bizarre and morally questionable. So let's move on. I think they planned it from the get-go that that's what they were waiting for. That's an assumption to make. However, there is a good likelihood that even if they didn't plan the exact moves, that they did have a plan to start changing the course of the case when least expected. So even if they didn't have the exact move plan, I do believe they did have a prosecution plan in place to throw off the defense. So I do believe that existed as part of their strategy. Uh, as far as the exact moves, I don't know how far in advance they thought those out. At least with the ninth indictment, for them to have thought that out when it first began, probably a little less likely, but for them to have thought that out once they found out that there was a potential case from the civilian prosecutors, more likely. Do keep in mind, the military prosecutors got this new indictment through the civilian prosecutors who found it and decided to add that indictment to the main principal in the first degree, whose name again I'm not mentioning, but I'm going to call him Mr. Y because he is Mr. Y. You guys all know who I'm talking about. So they inherited that part of the case. Well, they inherited all of this case, but this particular wild card that they threw at us, this new indictment, inherited. So even if they didn't know this from day one, they definitely started having strategies with this particular thing from that moment on. It was concerning to me when they also added this particular indictment, because there is something that is in nature very different to the other indictments. When the other indictments came, I often said that we're looking at prostitution mediation. It's something that's really not a very serious crime. Again, if you follow me, you'll know that I don't believe that prostitution and prostitution mediation should be criminalized. I believe these should either be legal or decriminalized. Those are two different topics that I will discuss at a different time. And there are many different jurisdictions around the world that either have decriminalized those or do not believe them to be crimes at all, and they are legal. So I thought those two were not very important, and that was still one of the main charges. The other was embezzlement. And if you look at the case, you will see that both instances of embezzlement were not done with malicious intent. There was no intent to embezzle. That was another instance where the defendant was rather uninformed and naive and did something accidentally that can be considered to be embezzlement. Remember when I said you have gone out to dinner with a couple of buddies and you happen to pay for your dinner with your business credit card and you are now charged with embezzlement. Embezzlement is really that uncomplicated. You can be charged in many ways with embezzlement. So again, I was not as impressed with that charge or as concerned. This one, however, was instigating violence, in this case, aggravated. The word aggravated is what got my attention to begin with. Aggravated charges tend to be more serious, and because of that particular point, if this turns out to be guilty, that means the prosecution has asked for 5 years total, and they've asked for 5 years with labor. Many people have asked, how could they ask for that many years? I haven't seen many people in my DM asking me, how could they ask that plus labor? The reason they can ask for 5 years and the reason they can also ask with labor is because of this last ninth indictment that has the word aggravated. With them having changed this to not just instigation but co-principal, it now gives them the legal right to ask for 5 and to ask for labor. when I'm talking labor, I'm talking prison labor. Again, why this one threw me off. There wasn't very many things that have thrown me off throughout this case, not even the judge's questionings. None of those threw me off. But this threw me off because this wild card that we have has created the most advantage the prosecution has so far. All of their other moves have been very lukewarm. They've been like, meh. There's so many holes in their cases. It's like Swiss cheese until now. So this one is the reason everyone's been asking, how could it be 5? This is why it can be 5. This can be 5 plus labor because of this one. What are the chances that it's going to be guilty? As we said, if we only take the prosecution into account, then it becomes pretty high likelihood. It creates a more even playing ground. Then it will depend on the judge's reasoning. I cannot say if I'll agree with that reasoning at the end of the day. I might believe the reasoning is incorrect. I may believe the reasoning hasn't taken certain factors into account, but it will depend on the reasoning. If they find him guilty on this, but let's say all of the others are innocent, the sentencing is really going to be very, very interesting because let's say out of the 9, he's now guilty on 2, but innocent on all the rest. Then it's not a very bad prospect. However, this one is aggravated charge. So you're still looking at about they're going to try to still keep labor, and they're still going to try to keep it at 3 or above. But if there is great arguments put in through the defense, then even if it's 3 years or 2 years, then you can get that suspended. The chances of suspension are again going to become higher. The better the defense is, the higher the possibility of suspension. For suspending a sentence, it's not just the legal arguments that the defense is going to give. There's other factors that play a huge role in court. It's true here in America, it's true in UK, it's true in France and Germany. France and Germany are civil law countries. It's actually also true in Japan, the country where I have said there have been some problematic cases since it has the 99% conviction rating. Another story entirely. But even there, this holds true. Some of the things they'll look at is this a first-time offender? What are the offenses? How harmful are they to society? How much of damage have they caused? What are the likelihood that this individual would continue committing these crimes or other crimes similar? What are the possibilities that this person has learned their lesson and will not commit crimes again? They will live a life without it. What are the likelihood that the person may actually be a good person and not someone who's inherently someone who lives a life of crime? And if so, do we give them the chance to pay their due to society and wipe the slate clean? A probation does that. A probation says, we can see that this person deserves a second chance. This person is probably not really a hardened criminal who lives a criminal lifestyle and will probably not commit criminal acts in the future. The damage to society is minimal. The person shows remorse for their actions. whether those actions were committed on purpose or accidentally. For instance, the embezzlement, um, or for instance, casino chips that were used. That might not have been accidental, but that definitely was not malicious and that was not intended to be um, breaking the law. But taking all these into consideration, uh, the judge decides, are they deserving of having a chance not only to pay their due, but to pay that due and then move on with a new lease on life? So, for me, I would say if we can get a 3, I'm not very happy with the 3-year, but if we can get below 3, even with a 3, it's not too bad. But if we can get below a 3, a 2, and suspend that, that would be ideal. If we get a 3, I would want that to be fully suspended. So if there's a 3-year sentence, the only way I would be happy with it is if that 3 years was completely suspended and there would be absolutely no prison time. However, if it was a 2-year and it was suspended too, it would also be fully suspended at that point once it's less than 3. That would be what I would be most happy with, 2 or less and suspended. But if it's 3 and suspended with 0 prison time, then I'm willing to take that deal. The reason why, because again, I'm coming at this from a legal perspective. His freedom is at stake. His freedom and labor in prison is at stake. If you've never been to prisons or South Korean prisons, what prison labor would do to a person, you probably cannot imagine. So, given what is at stake, even though I would prefer a 2 or less suspended, I will bite my tongue and accept a 3 and suspended. If that shows you the reality of what the law and the criminal system is, um, it's not a bed of roses. It's not a utopian society, but I would bite my tongue if it's suspended, because suspension means this: in those 3 years, you've got probation. You behave the way you're supposed to behave. There's going to be a whole list of behaviors. You're probably going to have to face other restrictions, fines. But once you've done all of those things for 3 years, while you're still free, then after those 3 years, you've paid your debt to society. Whatever was owed to society has been paid, and now you have a new lease on life. So even if I don't find myself happy with the 3, I will still take it, because that means in 3 years, his debt to society will be gone. He can have a new lease on life. Anything below a 3, a 2 and below would make me a lot more happier. A 1 and below, I would be dancing on the streets. If we get a not guilty, the chances are I'm going to show up in PJs in the middle of the night. I would be that happy. But the chances of me showing up in the middle of the night in PJs with that much of happiness is not as likely as suspended sentences. I want to make sure everyone goes away with the reality in mind, the reality of a criminal case that has 9 indictments. So, of course, I want it to be all good for him, but we need to keep in mind what the reality of the situation is. All right, so we've got more questions and more comments. I'm going to sip water and read. So I'm trying to understand the seriousness of this charge. What is the outcome of SR's involvement? Nobody was murdered. Nobody ended up in hospital. So what exactly are they expecting him to be? This is where it's so convoluted. I don't know if you caught the example of the poor guy. You probably did, since you mentioned murdered. But the reason it's convoluted is this. The charge is co-principal, but what is he charged as a co-principal to? What act is he a co-principal to? Is he a co-principal to shoplifting? Then it's not serious, right? He's being charged as a co-principal to a violent act, aggressive assault, aggravated assault, as you might see in many different articles. An aggravated assault is a serious charge. So let's forget the word co-principal for a while. Aggravated assault is assuming that you're assaulting someone. However, it's not just common assault, it is assault to a greater degree. So there's aggravating factors in a crime and there's mitigating factors. Mitigating factors makes the same crime less serious. Aggravating factors makes the same crime more serious. In an assault, one of the things that are considered aggravating factor is if you're inciting or if that violence is committed via weapons, via gangsters. And if you remember from the original, they claim gangster involvement. So the seriousness of this charge doesn't lay in the word co-principal by itself, but what the co-principal is attached to. Think about it. Suffixes and prefixes. Co-principal is attached to co-principal of aggravated assault. And that's why it's more serious than if it was just a regular assault or if it was theft. Aggravated assault is considered to be a more serious crime. Asai, well, I hope his defense team has managed to gather. We do too, knock on wood. As I said, it's now been several days since. Let's hope that entire team has done whatever they needed to best represent their client. At this point, I think that is one thing that the VIP community can do, is hope that they're doing the work that they should be doing. I worry that the defense may have a hard time finding similar cases to stare. Again, one of the reasons why I did mention that it has created a slight change in balance. Still not a very big change in balance, but enough that it had me worried, because it's hard to find very many cases similar. But they should still be able to find at least one or two. I mean, my case that I mentioned for you was a murder case. It wasn't supposed to be a murder case, but it became a murder case. But if they look in the entire history of South Korea, it can be in a history during Japanese occupation too, if necessary. They can even find old cases, if necessary, to build their side of the story. It doesn't mean it's going to be easy. So again, hoping that they're doing all the work they need to, including staying up at night. I hope there's lots of coffee or tea, and their team is working hard. Next question or a statement, let's see. And then the punishment is the same or changed depending on the level of involvement. Another great question. So we're currently being bombarded with comments and questions, but this one's very, very important. So the instigator punishment was a lesser punishment. So when someone was charged as an instigator, that meant that person, if found guilty, would be given a less severe punishment than the principal who actually did the offense. In this case, for a co-principal, that little word co or joint That tiny word really throws it all off. Now you're punished at the exact same level as the main offender, the one who's doing the things, at the exact same level of punishment. The only good thing is you cannot be punished more than them. And you might be thinking, in what jurisdiction can a co-principal be punished more than the main principal? You would be surprised to hear that there are jurisdictions on this planet Earth where the co-principal can actually be punished more severely than the principal. There are. Like I said, you'll be probably a bit shocked, but there are some legal jurisdictions where that can happen. So even though it's not a very big good news, it is still one tiny piece of good news that even though it's at the same level, they at least cannot punish him higher than the original main offender. That doesn't necessarily mean that it's going to make any of us feel any better. It probably won't, but at least sentencing wise, we know that it cannot go above a level. So won't make you feel better, but sentencing wise, we know it cannot go above a certain level. It'll have to remain there. Morally questionable. What moral do they still have? And that's the question of the day, right? When there are so many things that fall within the letter of the law, and yet there are things that are allowed that are iffy and make you wonder, wait, can this be moral? It's time that those codified laws and the way that society works changes, right? So there's definitely a lot of room for improvement in that particular legal system, and hotly debated facts about society, creating legislation, and so much more that's possible. But not the topic for today's discussion, since we're sticking to his case, but a lot of room for that type of debate. Was not the people that apparently did the assaulting, were they not bodyguards? And if they were bodyguards, did they not have the right to intimidate a person that is bothering the person? All right, another really good statement / question. It's a little bit of both, isn't it? So while this charge was brought in with it linked to gang violence, thus aggravated assault. During the hearing, it has been found and revealed that the individuals in question were bodyguards. So correct on that. That's part of the defense that I was talking about, the defense can build using the testimonies. So this is part of that testimony that the defense will use. So when I say the defense is going to use the testimonies already given in court, this is some of them. They're going to literally use that part. Pull where they say it's, aggravated assault because they're gang members. They're going to say they weren't gang members, they were bodyguards. How do I know this? Here's how we know this. So that's part of the defense, is using the testimony that I was talking about. The second part is a question. It says, did they not have the right to intimidate a person that is bothering the person? So what are the rights of a bodyguard? Okay, so so these are more gray areas in the law. So bodyguards' job is specifically to protect, to guard, to run interference. Intimidation can happen, but in a limited fashion. Intimidation cannot make someone feel unsafe. It should not involve any kind of bodily contact. in this case, in South Korea. Um, in America, if you see bodyguards physically walking someone out of some place, it's usually a property owned by the people that have been breached. So if a club owner has a club bodyguard or a bouncer, they have the legal right to grab someone by the collar and shoo them out the door. But a guest in that particular club does not have the right to get a bodyguard, and that bodyguard then grabs the person and takes them out. That one is not one of the things. South Korea has another law that is strange, and I personally disagree with this one. If two people get into a fight and both hit each other, the person who started the fight ended up, let's say, giving someone a bloody lip and a huge bruise in the eye. The person who is defending themselves fought back. Maybe that person was a better fighter. Despite themselves being bruised, they managed to break their attacker's nose. The police come in. The police will charge both the individuals, the attacker and the person who got attacked, the victim. Both get charged. Both go to court. Both are faced with the same liability of having fought and assaulted each other. As I said, there are many kinds of gray areas in law, and there are some that plainly don't make a lot of sense. That one, they do it because they believe, and it has to do with philosophy. And remember how I talked about Confucius? This comes from that particular philosophy. It's evolved from there. That it doesn't matter who starts a fight. That does not matter to them in their philosophy. Okay, doesn't mean that you have to agree with that philosophy, but you need to know where that philosophy comes from. The instigator, the person who starts that fight, is unimportant. What is important is a fight took place and two individuals hit each other. The person who causes the greater damage bears the greater responsibility. The poor victim is bruised and protected themselves, happened to be lucky enough to be a better fighter, so broke the other guy's nose, greater damage. While both get charged, both get taken to court. At the end, the person who's going to get the harsher punishment is going to be the victim. In this case, the victim is not going to be thought of as a victim. They're going to be thought of as a co-principal. They're also responsible. In America, they would be considered a victim, and it would be considered self-defense. In South Korea, they're both principals, principal and co-principal. And the one that caused the more damage is more liable for punishment. Not saying these to make you guys feel scared, but saying these so that you get a perspective on what I'm talking about, how legal philosophy impacts the way a code is written and how that code then is applied in the legal system. Prosecution also asks for revelation, notification of personal information, as well as job restrictions. What would those mean? Okay, excellent question. So we've covered the sentencing. Let's talk about these other parts. As I said, even if there is a suspension of sentence, there's going to be a